Good morning or good afternoon, everyone. Thank you for joining us for today's session of Leaders in Law. Now, before we begin with our honored guests, we have a couple of quick housekeeping announcements. The first announcement, you may have noticed that you're currently in listen-only mode. This is to cut down on the amount of background noise and to ensure that everyone can hear our speakers. You are welcome to ask questions during today's presentation. On your GoToWebinar pop-up, which should still be on your screen, there'll be a button that's labeled Questions. I'll be monitoring that channel and make sure to ask any questions of the presenter towards the end of today's presentation. Our second quick announcement. Today's session is not for CLE credit. Again, I repeat, today's session is not for CLE credit. However, if you're interested in learning more about FastCase, we do have CLE sessions that are available. You can sign up for those on our website, fastcase.com/support. All right, so with that introduction out of the way, I'd like to thank everybody for joining us today on our retrospective on the great case of Gene v. Nelson. Our two speakers today and honored guests are, there we go, Erwin Stotsky. Mr. Stotsky is joining us from the University of Miami School of Law and has a really distinguished pedigree that I could not do justice to on the small amount of space on our slide today. However, he has been a fantastic participant in today's webinar, so I will let him introduce himself further in just a moment. But I also want to introduce our other speaker, who is, of course, Ira Kurzban, who is a founding member of Kurzban, Tetzley, and Pratt Miami, and has also been a wonderful presenter. So with that, I am going to ask our starting question, and then I'm going to turn it over to our guests to continue from there. So, of course, the starting question that I have to ask is if you can set the scene for today's case. Can you tell us a little bit about the political environment and situation that arose prior to the case of Gene v. Nelson? Can you tell us about the politics and anything else that impacted that situation?
Okay. Well, okay.
Erwin and I are going to talk over each other for the next 2 hours.
In that case, I'll start. At the time that this case arose, the Duvaliers ran Haiti, one of the most repressive regimes that served from 57 to 1986, first with Papa Doc and then with his son. And it's said they systematically assassinated about 60,000 of their own people. They took their state funds and used them as personal bank accounts. They had a security force known as the Tonton Macoutes, who did whatever Duvalier told them to do, killing people, stealing their property, terrorizing them. Haiti was not a pleasant place. People wanted to get out of Haiti for basically that reason. If you were imprisoned in Haiti, you had a 76% chance of dying within the next year. The first year, either because of illness or because of mistreatment. So, and by the way, the US gave them billions of dollars under the auspices of Papa Doc stopping the commies from coming to Haiti. At the same time, we have to remember the US occupied Haiti for 15 years up through about 1935 for commercial reasons, cheap labor, agricultural, and all that. And they set the stage for the creation of a Haitian army that fought nobody but their own people and killed them at will. So that was sort of the circumstance of Haiti. Ira, you want to add anything about that?
Sure. I mean, we could, I guess, talk about the entire. We could go back and both, I think, go back and go forward. But I think what Erwin is saying is, a really good description of the context in which Haitians were fleeing Haiti. But the history of Haiti is an incredible history. Haiti was the colony first when the Spanish came to the island of Hispaniola. They say the first place in 1492 that Columbus may have in fact discovered was the island of Hispaniola in what is today part of Haiti. The Spanish, as we all know, then proceeded to commit genocide on the Indian population in the island of Hispaniola, basically killing all the Taíno Indians, Native Americans that lived there, and then had to substitute them with slaves, which they brought, as you know, from Africa. And so Haiti became really, in many respects, a French colony, and then a French colony dominated by slavery, and became the richest colony in the world, actually, in terms of delivering coffee and other goods to Europe during the 15th, 16th century and then beyond. Then what happened, of course, is Haiti became the first democratic slave revolt that resulted in a democratic republic under Toussaint Louverture, and as a result became a threat to most of Europe and certainly to the United States, who failed to recognize and refused to recognize Haiti until the Civil War. We didn't recognize Haiti from the time it declared independence in 2001. I'm sorry, in 1801 until 1863, during our own Civil War, and basically had a hostile policy toward Haiti even after that, because it was the symbol for the rest of the world as the first successful slave revolt of Africans at the time, and then resulting in a constitution, which Erwin can probably talk about much better than I could. With respect to equal treatment of all races and so forth. So it was perceived as a threat. The French in 1823 tried to reinstitute slavery in Haiti and sent warships to Haiti. And as a result, Haiti was forced to become indebted to what was amounted to about 150 million gold French francs, which Erwin and I worked on a case together, and we estimated at some point prior to President Jean-Bertrand Aristide's second coup was worth about $21 billion. And Haiti became an indebted nation. That's why when you hear things like Haiti's a failed state and somehow this is all due to Haitians, Haiti was the subject of incredible repression, economically, politically, and otherwise for over 2 centuries. And when the French finally left, the Haitians were miserably indebted to the French. The US government came in, and the first act of the US Marines was to go into the National Bank of Haiti and literally take out all the gold on behalf of US banks. Right. And then proceeded to occupy Haiti from 1913 to 1937 or
35, something like that. Yeah. Let me add something, Ira. When the French left, they left a class of elite Haitians. And what the elites tried to do was to recreate the plantation society. So what they did, it was a brilliant strategy. They kept the Haitians on small plots of land, and then they stole their labor by charging excessive taxes on the coffee and whatever else that they were growing. And then the elite became traders, foreign government officials, etc. And this disparity between the small elite and the rest of Haiti continues through today. And so while France allegedly left, what they did was create a class of people to do exactly what the French were trying to do, which is really to re-enslave the Haitian people. So that society that exists today is very similar to what happened many years ago.
And remember, we sent troops into Haiti at a heightened time of blatant discrimination in the United States. At the time, the Ku Klux Klan was very powerful, at the time of mass lynchings in the US. So the treatment of Haitians by white Marine soldiers was repressive, outrageous, racist, resulting in the death of many Haitians who sought liberation. And the US's legacy in Haiti, as Erwin pointed out, was to create a military army that would be, that in effect would work at the direction of the US. So there was then coup after coup, government after government. The army played a central role. The Haitian army played a central role in keeping the country actually in a state of instability and non-democracy for many years. We started representing Haitians when there were people who were trying to fight the Duvalier regime. And so that's kind of the political context. The legal context, I think the issues with respect to immigration and refugees actually started in 1973 with a boat called the Saint-Sever, which interestingly enough was stopped in Guantanamo and was helped on its way eventually to the United States. And what you saw in the early days of the 70s and the mid 70s was actually the United States taking a fairly sympathetic view to the few Haitians who came. Remember, this is in the context of the 1966 Cuban Refugee Adjustment Act. This was after Cubans came to the US. And as I always fondly point out, when we talk about tens of thousands of people at the border, I remind my friends that we flew 266,000 Cubans into the United States in 1966. And no one said that we were being inundated with people and that we couldn't handle it and our borders were being overrun. So the idea of, a family with 10,000 people coming to the border is somehow this great national crisis that we have to deal with is ludicrous and, is all a fantasy of the current Trump administration as a way of pitting Americans against one another and Americans against immigrants, because our capacity to take immigrants is substantial and was substantial even in 1966. If we could fly 266,000 people into the United States from Cuba, we could certainly take people at the border, relocate them throughout the United States and take care of them.
Yeah, that's good to say. Why don't you tell us how you first got involved in this and how you got me involved?
Okay, so let me just finish about kind of the boats coming to the U.S. and then toward the end of to the middle and end of the 1970s, the policy of the U.S. government changed with respect to how they would treat Haitians. So instead of having kind of a open arms policy to the few Haitians that came, in sharp contrast to how they were treating Cubans who came, they began, which was part of kind of institutional racism on behalf of immigration in the late 70s, and started to detain Haitians.
Right.
I was asked first by the National Emergency Civil Liberties Committee, which was a civil rights organization started in the 1950s, at the time when the ACLU was actually turning in their own members to the McCarthy Committee as being communist and so forth. A new organization was formed called the National Emergency Civil Liberties Committee, led by, I think, probably the best civil rights lawyer of the 20th century, Leonard Boudin, who, among other things, was involved in the seating of the first Black legislature in Georgia, was involved in the first comparable worth case, and was actually involved in the first major class action case on behalf of Haitian refugees here. And that was in the late 70s, and the cases were Marie Sinan versus the United States and Marie Pierre versus the United States. And they were ongoing in 1977 when I arrived in Miami, and not knowing anyone and not knowing anything, needed real brain power. So of course I knocked on Irwin's door and another colleague at the University of Miami and begged them for help to try and figure out how we could strategize about protecting those people in those two class actions, which were before two different judges. I believe one was before Judge King, one was before Judge Mertens at the time. And the theory, remember, this is the 1970s. So this is before the Refugee Act of 1980. The only law protecting refugees at the time was the United Nations protocol relating to the status of refugees, which the United States had signed in 1967, and another section of the Immigration Act, which simply said we wouldn't send people back to communist countries. And of course, the Cuban Refugee Adjustment Act, which allowed Cubans coming in to, within a year and a day, become residents. And so that was kind of the environment. And Erwin, I don't know if you want to take over from there. Or...
Well, what happened was we got interested in it. We were actually bringing students down to the Bay when the Haitians were coming in, interviewing them for asylum. And there was an organization that was created called the Haitian Refugee Center, which I oversaw. And there were a couple of full-time lawyers who did individual cases. And they were, and the Haitian Refugee Center, led by Father Jean Juste, was the center of Haitian life, really, for asylum claims and other kinds of legal issues in Miami for many years. And while that was going on, on July 2nd, in July of 1980, I believe it was, the Mario boat lift took place, which was and is, I guess, one of the largest migrations in the history of the United States, in which Fidel Castro let anybody who wanted to come to the United States to do so, and 125,000 Cuban nationals arrived in southern Florida. And it became a media event, a national media event. The press tried to capture the urgency of Cuban Americans as they took their boats over to try to bring their relatives, etc. As they came off the boats, they were processed quickly, released into the community, helped in a variety of different ways. At the same time they were coming over, Haitian boat people started coming over. However, they were not treated in the same way, to put it mildly. They were detained. The Chrome Detention Facility, I believe, was created at that point in time, at which point a couple of the attorneys representing the individual Haitians in asylum claims called to tell us that at least 10 Haitians had been deported illegally, and that we had to do something to stop it. That the lawyers were denied access to the Haitians. The Haitians were being brought down full time in the back corridors of the immigration courts. They're holding mass exclusion hearings for them without the right to counsel, without informing them of their rights, without telling them. Some of the translators, what they did tell them was, you better say you're going back because you're going back anyway, essentially. And that went on, and I was still working on Haitian cases. Stephen Ford, who should be, should be acknowledged, called. And we called up the emergency judge in the middle of the night, I believe it was. And it turned out to be a former law student of mine. And we asked him to get the judge on the phone, and the judge didn't want to. He said, I can't wake him up in the middle of the night, but eventually he did. And he stayed, I believe, at that point until we could file papers, which we filed, I believe, a habeas petition the next day or the day after. And then eventually amended it, and we had to have hearings on those issues.
Yeah, if I could, just let me take again a step back. In the late 70s, the Haitian community began to organize itself, which ultimately resulted in the formation of the Haitian Refugee Center on September 17, 1980. But between the late 70s and the formation of the Haitian Refugee Center, Haitians worked under the guidance of the Christian Community Service Agents in the National Council of Churches. And what they did is they started to accept, as more and more Haitians began to come in to South Florida on boats, they began to process there and help them with asylum claims that they were making. And as a result, the response of the community at the time, unfortunately, and the response of immigration was, this is not going to be a problem. These Haitians are not going to be here long. And they started something called the Haitian Program. And the Haitian Program was a program designed to expedite the deportation of Haitians out of the United States as quickly as possible. They were having multiple hearings in different locations to try and kind of mass remove people. That resulted in the first case, which was called Haitian Refugee Center versus Civiletti, which Erwin was involved in as well. And that case, while that was going on, the McDuffie riots were going on in Miami. Cubans were coming from March until about May or June of 1980. And then Judge King, in a memorable opinion on July 2nd, 1980, entered an order in Haitian Refugee Center versus Civiletti, calling what the government was doing, this Haitian program, as blatantly unconstitutional and discriminatory. So while that case went on, we then had an election in the United States. Reagan gets elected, and Reagan says, through his attorney general, we are going to do three things. We're going to interdict people in the water. We're going to expedite their removal hearings, and we're going to detain them. The detention part, interestingly, was related to the fact that at the time, the private detention company that existed was owned by the major donor to the Republican Party. This was in 1980. That's a company that has since become CoreCivic. It was the Corrections Corporation of America. They received, through Reagan, the first contracts to begin to detain immigrants. That's how we had an immigrant detention policy, because before 1980, we didn't have a detention policy. The policy
between 1954 and 1980, there was no detention. Between 1954 and 1980, there was no detention policy.
There was no formal, once in a while, obviously they detained people, but there was no formal detention policy. This was the announcement of the Reagan administration. We're going to interdict, we're going to detain, and we're going to expedite removal. The problem was, of course, as Erwin well knows, they only did it to Haitians. They didn't do it to anyone else. And that was the beginning of Jean V. Nelson. And what Erwin was describing was, all of a sudden, Haitians get detained, resulting ultimately in 2,000 Haitians detained, and then dispersed all over America. Haitians were taken to Buffalo, New York in the middle of the winter. Women were taken to West Virginia. Men were taken to Big Springs, Texas. And so we had a detention policy now that spread out through the United States. And that was and at the same time, they were denying lawyers access to people here in Miami, taking them to remote locations where there would be no lawyers, and also interdicting Haitians who were trying to come in by boat and trying to turn them around, allegedly giving them asylum hearings on the boats, but they were totally meaningless. And what they were really doing was just interdicting them and sending them back. Duvalier ultimately entered into an agreement, which was ironic, of course. Here you have, as Erwin described before, one of the major dictators, brutal dictators of the Western Hemisphere. President Reagan enters into an agreement with him saying, we'll accept people back and we won't harm them, with a wink and a nod, obviously. That was the context in which Jean V. Nelson began. And it began with Marie-Lucie Jean, who was detained at the Krome Detention Center. And interestingly enough, when we talk about Krome was a Nike missile base. It was missile aimed at Cuba. It was basically decommissioned and became one of the very first immigration detention centers run by immigration. That was the genesis of Krome. You know, there aren't that many that are actually run by ICE, Immigration and Customs Enforcement. Most of them are contracted out to these private contractors, like the Corrections Corporation of America and others. Now CoreCivic and GEO are the two major private companies. But Krome was the first major detention center of the Immigration Service, then the Immigration and Naturalization Service. And half of it was divided between Cubans and Haitians. And Erwin, you may remember, one of the most stark things about it was how Cubans were treated versus Haitians. Cubans were taken on trips outside of the detention center, to movie theaters, to others, and Haitians were kept in really disgusting conditions at Krome.
Also, the Cubans were allowed phone banks, visits by their relatives, and were released pretty soon. Haitians, as you said, were treated with less than dignity. Yeah.
So that was the genesis of Jean V. Nelson. We went out to Krome. We talked to some of the Haitians who were detained, Marie-Lucie Jean. The case really began with another person, ironically named Nelson. So at the beginning, it was Nelson versus Nelson, if you remember, Erwin, at some point. And what Erwin was talking about is what happened at the very early stages when we were before Judge Alcee Hastings. And maybe you want to talk about some of the legal issues and what happened there.
When we went in front of Alcee Hastings on a habeas, and we asked him to issue a temporary restraining order. And to get a temporary restraining order, you have to prove you have a likelihood of success on the merits, that in balancing you're likely to succeed on the merits. There's irreparable injury, balancing the interests. The interests are favorable to the plaintiff and not harmful to the defendant, and it's in the public interest. So it was pretty clear that we proved all of those kinds of things. The government really didn't have much to say about it. But there was some kind of agreement between, it turned out to be between Judge Hastings, the government, and us, that the government would not send any of the Haitians back pending this. But in July, and we had a couple of days of hearings, but the judge never issued a TRO. And he didn't until September, in which he held 3 hearings. And we always wondered why he did that. It turned out, I think, that at the time, Rudy Giuliani was third in line in Justice Department, which he never failed to tell judges when he came to court. And he was also in charge of the criminal division. And they were investigating Judge Hastings for a bribery charge, by the way, which he later was found not guilty of in a criminal trial, but was nevertheless impeached, going out of office at some point in time. And in footnote history, he became a wonderful legislator and still in Congress to this day. But in any event, That was going on behind the scenes. Rudolph Giuliani was coming down here, dating one of the TV reporters. And that's how he decided he was going to get free trips, the best I can figure. And so he was part of the team. He also testified at trial and did one of the appeals in which he was an awful lawyer, to be honest with you. And he probably perjured himself on trial. At least that's what the judge panel on the Fifth Circuit implied in the footnote when he said he was disingenuous in his testimony. By the way, the footnote later disappeared from the reporter. So that's the context of the hearings that we started. Now, Ira had a full, yet this case was a full-time plus job. He was doing all of that. Several of us also were teachers, and we were trying the best as we could to help in that endeavor. One other story which is important is, as far as I could tell, we couldn't get any law firms in Miami or anywhere else to help us in this case. So finally, an immigration attorney in Fried, Frank, Harris, Schreiber, and Jacobson helped us, and he got the firm to work with us, and that's Bob Jusian in this case. And Ira was friends with him, and that's how he got him involved as well. Go ahead, Ira.
And you know, the context of all this was really the following. We had to develop theories, I think, that weren't that well thought out prior to our bringing this lawsuit.
Sure.
And that's, I think, Erwin and Bruce Winnick, who were the two professors working on the case with me, the law firm of Fried Frank, and then we had a group of incredibly dedicated lawyers at the Haitian Refugee Center, Vera Wise, Steve Forrester, and then later on, some other lawyers who went on to work in the Senate and work at AI Justice, you know, Cheryl Little.
Right.
And so we were very lucky that we had a motivated group of people. But part of the strategy of this whole case wasn't just a legal case.
No.
It was a case that was brought in a much broader context, which was the demanding of Haitians' rights. And so there are kind of two ways that people always discuss the literature of doing civil rights cases or immigration cases. Is it done from the top down, which in many respects was how the NAACP did cases. You know, they decided to pick and choose which case as a way of moving the law forward. Or the other way was really the way that we did it, which is we were responding to the demands of the community in doing these cases. In other words, Haitians were coming to the Haitian Refugee Center and saying, we don't have the right to work. And we wound up bringing the first lawsuit ever on employment authorization for asylees. And as a result of that, we ultimately got employment authorization, which ironically, this administration is now taking away from asylees by their new regulations. But we actually generated it through the demands of people in the community saying, look, I'm seeking asylum, but I have to have some way in which to survive while I'm here. The same thing was true of Jean V. Nelson. People were coming to us and saying, my relatives are being detained. I don't have a lawyer. They're rushing me through these cases. They're depriving me of the right to be heard. And they would be filtered at the Haitian Refugee Center under the direction of Father Gerard Jean-Just, who, you know, was in those days, and may he rest in peace, who we believe was actually killed by the coup regime in Haiti. But during his time in Miami, he was like the Dr. King of Miami. I mean, we were in demonstrations every day in Miami. There were demonstrations throughout the week in federal court. We'd have a hearing, as Erwin well knows, in the old grand courtroom in the old post office that would hold 300-400 people. It would be packed by Haitians coming. So this was an organized effort to, first of all, talk about the rights of Haitian refugees in the United States and show in, stark contrast to how they were treated versus Cubans coming in to the same place, the same time, the same area with the same aspirations, and they were treated totally different. So this was a movement, not by lawyers, not by us really, but by the Haitian community itself, who dedicated their time. People like Bernard Fils-Aimé, Raoul Chambart, Abel Simon, Gabriel Augustin. These were the original people who moved and started the Haitian Refugee Center and created the environment necessary to litigate these cases. The second part, again, which was not really a legal part in some sense, was not only this movement to show that Haitians were being treated unfairly and discriminated, but to show the conditions in Haiti. So the strategy in these cases was not simply a pure kind of theoretical legal argument we're going to make, but what we wanted to do, and we did, was to put the Haitian government on trial to show that while the US government was saying, oh, well, unlike people coming from Cuba, Haitians are just, quote, economic migrants. That was the term that was used. And even today, they use that euphemism with people who are fleeing for their lives from Guatemala, Honduras, and El Salvador. They call them, quote, migrants. They don't want to call them refugees. So we're in a situation where we were going to prove in federal court that these people were refugees. They were being discriminated against because of their race and because of their national origin. And we needed to come up with some theories. And part of those theories, I think, are the ones that Erwin and Bruce and myself and the law firm of Fried Frank developed. And one of them was the Administrative Procedures Act. I don't know if you want to talk about that and the discrimination claim or what.
Before, I just want to put what Ira said in one sentence or so. These were not just stark legal cases. They were used as organizing tools, pushed up from the bottom by the Haitian community to highlight the discrimination and violation of the rule of law against a particular nationality and racial group. And, as Ira said, to show the oppression in a foreign country that had been created and enforced by international and national groups, including, perhaps most importantly, the United States in the more recent years. So we put the United States government on trial as well. It wasn't just the Haitian government. And we could see that in the testimony of the American officials who, for example,
particularly Giuliani, who you probably started to talk about before, who testified as he was the Deputy Attorney General of the United States, the third highest ranking member of the Department of Justice, got on the witness stand and just lied, as he does today in public, but then under oath lied and lied and lied about the conditions in Haiti and said everything was okay. People could go back to Haiti. There would be no problem in their going back because he talked to the papal nuncio, and the papal nuncio in Haiti assured him that everything was fine, even though it was well known.
In there. While this was going on and he made that testimony, I called the papal nuncio in Haiti. I don't know if you remember that. And the papal nuncio said it was a total lie. So I said to him, we have a first-class ticket waiting for you if you would fly to testify. And if it had been testified in front of Judge Spellman, who was a lay official of the Catholic Church, it would have been incredible. But he wouldn't do it, and he wouldn't sign an affidavit or anything like that. It was clear he was very upset that Giuliani would make that claim. But it wasn't just Giuliani who made those claims. It was Nelson, who was the INS commissioner at the time, as well as Joey Howerton, who was the head of Chrome. And they all told different stories, equally deficient in truth, let me put it that way, about their policy. And this leads into the Administrative Procedure. Under the Administrative Procedure Act, we have a new rule. You have to give notice, and it has to be published, and you have to give 60 days for responses by people. Instead, they just created a new rule with none of that. So the remedy for that is to go back to predating the new rule as to how people were supposed to be treated, which is why Judge Shelton ruled that the Haitians should be released at that point. That was a novel.
Erwin, the rule at the time, prior to this change in policy under Reagan, when he made this announcement, the rule was people would be released, even though
Yes.
the statute, this was section 212D5, the section of the act says you shall be detained, but shall. Sam Bernsen, who just recently passed away, who was the general counsel, testified, if you remember, on our behalf.
Yeah.
Others testified who were experts in the field, saying, even though the statute said shall, it was always determined that people would be released unless they truly posed a threat to the national security or, otherwise known to be criminals or harmful to society. If you came in at the border, you were released. All of a sudden, after Reagan's speech, they decided to detain everyone, but everyone was defined as Haitians. One of the things we were able to prove in the lawsuit was that the chances of the government detaining Haitians versus releasing non-Haitians was the equivalent, we put a statistician on the witness stand, of flipping a coin and getting heads 1 billion times in a row, because the government was saying ridiculously, oh, it just happens that we're detaining Haitians and other people are getting released. And it was ludicrous because it was clear that they were just detaining Haitians. So that was the discriminatory part. What Erwin's talking about is the APA part. The Administrative Procedures Act said you just can't change a rule without publishing it in the Federal Register and giving the public an opportunity to comment. They never did that. They just detained all the Haitians.
Right.
And,
one that it wasn't a new
from
rule.
Erwin and Bruce was really about the Administrative Procedures Act. And ironically, today, it's used all the time in immigration cases. It was never used until I think we used it in our case.
As far as I can tell, that's correct. Yeah. The other part of what Ira was talking about in regard to using a statistician, that was incredible. There were 3 separate sets of data, airport, boat, and I can't remember the third one. But we got the judge to appoint as special masters 20 law students at the University of Miami. I don't know if you remember that, Ira. And they went and they counted the statistics with the INS officials, and the government had a collective stroke over it. And they said, this is not acceptable. And Judge Feldman said, I think this is a great idea. Yeah. And so the statistician was really, by the way, I've spoken with him recently. I hadn't spoken to him in 30 years or 40 years. And he recounted how that was interesting. And he used chi-square analysis and all these other kinds of statistical methods to show that it couldn't have been anything but intent. In those days, as today, in order to prove an equal protection claim, you have to show a disparate impact on a particular group and an intent. The intent part is the hard part. So I think if we were to look at our case, this has to be the best case. I don't mean because of necessarily, but the best proven case in terms of creating an equal protection claim that I've ever seen, including all the equal protection cases I've ever read. And the proof that we had, witnesses, Ira got the former INS commissioners and lawyers testify. We got documents from the government that basically said, this is discriminatory. High-level officials saying these kinds of things. We got witnesses, lawyers who represented Nicaraguan and other groups who said they'd never seen this kind of treatment. We even got Larry Mahoney, who's head of the Cuban Haitian Task Force at Rome, to testify about the disparate treatment between Haitians other groups, particularly Cubans. It was incredible. Document, witnesses, whatever. And I would put that part together for sure.
You know, the interesting, I think, thing from a legal point of view about this case and what has changed in litigation over the last 30 or 40 years is the access to which we were given discovery. You know, the lifeblood of any real litigation is what evidence you can get, what documents you can get from the government. Remember, this is a case where I took the deposition of Rudolph Giuliani. He was the third ranking member of the Department of Justice at the time. I took the deposition of Nelson, who was the commissioner of immigration at the time. Today, if you go in front of a federal judge and you ask to take the deposition of some low-level government official at the border, you're always questioned as to why you need that deposition. You know, what's the point of it? Why can't you just ask them interrogatories or send them a request for production? And the evidence that we obtained, just to show you the difference, we obtained the documents that Ronald Reagan signed off on as President of the United States, demonstrating that they were detaining Haitians. It was literally a check off the box. Detain Haitians or not detain Haitians. He checked yes. You know, and so that kind of document is inconceivable today. I mean, if we look at all the litigation that's gone on with respect to the Department of Commerce and just trying to get the testimony of the Secretary of Commerce and trying to get documents from the Secretary, it's a dramatic shift in our ability to know what our government is doing and to hold the government accountable. And the way that they have done this is by limiting discovery, limiting interrogatories, limiting depositions, limiting notices to produce, and, you know, literally written into the rules. You can only have a certain number of depositions. And if you want to hire a government official, you know, I remember just 5 years ago going into court and having to argue, could I take the deposition of a deputy in one of the branches of ICE? And I, you know, quoted to the judge, United States versus Lee, no person in the government, no matter how high or low, is above the Constitution of the United States. And I was looked at in some bewildering way as if I was demanding something that was impractical or illegal. But Gene B. Nelson was possible only because we were able to do that discovery, which is foreclosed today, both by pleading requirements and by discovery. Sorry, Erwin, go ahead.
Well, that's all right. I mean, just look at the Supreme Court deciding that the district attorney in New York can try to subpoena documents from a third party regarding crimes. They fought that all the way up there, and they, you know, they'll never see those documents probably until after the election. So, right. And then of course, Congress tried to subpoena documents. Congress can't get any of the executive officials. It's just hard to believe. Anyway, along with this case, we have 2,000 people to represent. And as you recall, because we asked the judge to do this, we got the Dade County Bar Association to get 300 lawyers pro bono to represent individual Haitians while we did the class action. The government had another stroke over this, if you'll remember. And finally, the judge thought this was a wonderful idea, so he said, let's do it, and they did. At the same time as these people were representing their clients, none of us who represented the class action could get in to see the clients. They kept people at Chrome waiting for hours at a time saying, oh, we can't find this guy or whatever, as you recall, Ira, right? Yeah. And then the other part of it was that Judge Spellman appointed a special committee to help him with the appointments of lawyers and other things. It was, as you recall, the former the former ABA president. What was his name?
I don't know who.
You know, you remember? Oh my gosh, he was the most famous, one of the most famous lawyers in Miami. He was the dean of the University of Miami Law School, Sawyer Menchikoff, and some other people. And Spellman, his name was Chesterfield Smith, and he was asking for that Richard Nixon be impeached when he was lying to the committees and this and that. In any event, that created some tension among the lawyers, because two of us were professors at the University of Miami Law School and had been hired by her, and we thought that the appearance of an impropriety was wrong. Also, we didn't want other lawyers telling the judge how to rule on anything. We wanted him to listen to us, but he did that nonetheless, and we had to deal with those lawyers as well. So.
And I think through Robert Trusam and Chesterfield Smith, they organized hundreds and hundreds of lawyers to go out and represent people, which, you know, from a political point of view, was a very interesting way of nationalizing what was going on. So this no longer became kind of a local event. You had lawyers in Buffalo, New York, or Big Springs, Texas, or in West Virginia, now representing people and talking about it. You know, in the same way, I think in later years, we had people talking about what was going on in Guantanamo. So when you had lawyers involved on a national scale, the issues became much, much more heightened. And one of the things that happened was this became the focus of the Organization of American States. They sent a delegation for the first time ever into a United States detention center to determine how Haitians were being treated, which was extraordinary and unusual.
They claimed that we were violating international human rights laws, which is the first time, I think, ever in the history of our country that claim was made.
So, you know, we don't have a lot of time, so let me just kind of go through, I guess, some of the other steps, Erwin, you know, what happened. Judge Spellman ultimately entered a decision that said, under the Administrative Procedures Act, the government hadn't followed the notice and comment provisions, and therefore the Haitians should be released.
Right.
The government and said he didn't believe there was discrimination. And I quite honestly, I think he did that because he thought if he split the baby and showed that the government wasn't discriminating, but released everyone would walk away happy. He didn't count on Rudolph Giuliani. And Giuliani went into Spellman's chambers. I don't know if you knew this, Erwin, but he went into Spellman's chambers and in a very aggressive way chastised him for his ruling, which I learned later on, years later. And then an emergency stay in the Court of Appeals. The Court of Appeals rejected that out of hand. Many of the Haitians were released. The case, the government nevertheless appealed under the APA. We cross-appealed on the discrimination case. And Erwin, you may want to talk about what the panel opinion of the Court of Appeals said.
Yeah. Before I get to that, I also want to mention that when we did the appeals, we also talked to the Haitians community and asked them, what do you want us to do? And not only in this appeal, but to the Supreme Court, where there was a little dispute among some of the lawyers about whether or not we should seek cert, because several lawyers thought doing that lose the equal protection claim, never could use it again. But in any event, the case goes up in front of this three-judge panel. Giuliani gets up and he kept saying to the panel the following: "I'm third in line in justice, and my name is Giuliani." And then he didn't know much more about anything else. And finally, a woman on the panel kept saying, she made fun of his name and called him Giuliano, if you remember, and said, yeah, we know you're third in line in justice. Do you have anything to say about your legal argument? In any event, the 11th Circuit 3-judge panel agreed with Judge Spellman on the APA issue, reversed him on the equal protection claim, saying he was clearly erroneous, which is very rarely, I don't know if I've ever seen that before, done, and ruled for us basically on everything. We were elated, and I think 80, 90-page opinion, justifying every one of their actions, taking the officials apart on their testimony, Howardson, Giuliani, Nelson, basically, we didn't know if there was a rule or not. They don't seem to know. One has one rule, another has another one. They're all about the law. They seem to be, Giuliani in particular, seems to have lied on the stand, et cetera. It's really a remarkable opinion. I don't think I've ever seen anything like it. Go ahead.
Yeah, and you know, one of the things they said is that the discrimination against Haitians was so stark that it was reminiscent of a very famous Supreme Court case called Gamillion versus Lightfoot, where lines were redrawn to prevent Black Americans from voting completely.
Yeah.
And it was one of those, you know, phony redistricting cases that was so outrageous and so stark. And that's how the opinion described the evidence. They pointed to direct documentary evidence that said we were going to go after the Haitians and why we were going after them. They pointed to the statistical evidence, as we had said before, where, you know, the statistician said the chances of this happening were 1 billion to 1.
1 in a billion, Ira.
You know, how others were treated when they came in, testimonial evidence from lawyers, from former general counsels, from experts on immigration. And they also talked about, you know, Haiti. And, you know, because part of our case was to put the Haitian government on trial. And we had experts who testified, Debbie Anker and others, if you remember, testified about the political conditions and about people fleeing Haiti and why they were fleeing Haiti, that this wasn't just people trying to come and get a job. So that was an extraordinarily powerful factual presentation of what happened in a discriminatory way. And then the court took the case en banc. And why did they take it en banc? I think all you need to do is realize what Erwin was saying before. This was the era of, you know, 127,000 Cubans coming by boat. Many of them were put in the Atlanta penitentiary because they had criminal backgrounds. So they were there in Atlanta. This was the 11th Circuit now. There was now you know, the old Fifth Circuit split into two courts, 5th and 11th. This was the 11th Circuit sitting in Atlanta. They were very well aware of all the Cuban cases that had been brought about, detention of Cubans who had criminal backgrounds and so forth. So when you read the in-bank opinion of the 11th Circuit, which ironically said the following: we're not really going to discuss the facts because they knew the facts were so overwhelming that there was little that could be done. They really didn't discuss the APA except to affirm it and say we were right. And they focused on the discrimination and basically said on discrimination, if the Attorney General wishes to discriminate, he has the authority to do so under the Immigration and Nationality Act, which was shocking because we were alleging not only national origin discrimination, we were alleging racial discrimination because it was clear that these were the first Black refugees coming to the United States seeking freedom in a very dramatic way. And for the court to basically say, we're going to ignore all that evidence of the panel opinion. We're going to ignore the blatant racist discriminatory conduct, the national origin discriminatory conduct. And, we're only going to talk about national origin, and we're going to say that the Attorney General can make distinctions based on national origin. And that's what the in-bank opinion did. But, I will never forget, Erwin, you may remember this at the oral argument, where they asked the government's attorney, who said, well, look, we can do anything with the federal government. And so you can interdict people in the water and just turn them back, even though they're going to be executed. Yes, we can do that. And I remember one of the judges asking him, does that mean that you could actually shoot the boats down in the water and just let people drown in the water? And he kind of laughed, like that nervous laugh, and then said, well, that's not the issue in this case.
Right.
But the government's position was incredible. I mean, the government's position was, if you are not physically present in the United States, you have no rights whatsoever, and we can do anything we want to you.
Let me stop you for a minute. The N-Bay court suggested a non-constitutional standard, facially legitimate and bona fide kind of standard, but only to review low-level officials in what they're supposed to do. But the idea that you could shoot someone across the border and there would be no constitutional or other kinds of concerns, the Supreme Court just upheld that in the case of Hernandez versus Mesa, where a Border Patrol officer shot across the border and killed a 15-year-old kid for nothing. And the court said, well, he has no remedy whatsoever. And so that argument is the way they view people who they claim are different than the rest of us, which is amazing because every one of those judges either are immigrants or the children of immigrants, but they soon forget that they are. So you're right that in-bank opinion also did something else that was despicable. They basically said that under the Constitution, Haitians are not persons. I mean, directly by that opinion. So we had a meeting with the Haitians about should we apply for cert. I recall many of the Haitians saying, they don't think we're human? We're not people? I don't know if you remember that meeting, but that's what I recall from that meeting. And then we all voted. Some voted not to seek cert, and others voted to seek it. And we went ahead, we filed a cert petition, and much to our surprise, the Supreme Court granted cert, because I think you ought to know this. It's incredibly difficult, if you're not the government, to get a cert petition granted. So obviously, they wanted to deep six this case, basically, because as you said, when it got to the Supreme Court, and Rehnquist wrote his opinion, out of 11 pages of the slip opinion, 6 of them have to do with the procedures of the case, and he never mentioned the facts of the case, which is like what the 11th Circuit did. So it was amazing that knowing full well if he mentioned the facts, people would be upset as to what happened to the Haitians. Not only were they treated like animals, but they were sent back to face persecution. And the argument really was, we can do anything we want in immigration. None of the statutes can stop us. I redid the Supreme Court argument, so you should talk about it. But just quickly, we filed a claim regarding the Fifth Amendment equal protection issue. And I believe it was on oral argument. The Solicitor General changed the government's position on it and said there was no need to reach the constitutional question. We could decide the case on the statutory basis that since the statute is neutral on its face, there could be no discrimination. You couldn't be allowed to discriminate, which was a little surprising. Go ahead, Ira.
Yeah, I know. I mean, I think that was very interesting. Erwin's right. I mean, we argued that Haitians, of course, are persons within the meaning of the Constitution, whether they are at the border of the United States or in the United States. And of course, we pointed to lots of cases For example, if a Haitian is involved in a crime at the border, he's given all due process rights and is considered a person. The Russian volunteer fleet case, where there were issues as to whether or not property, when there was an issue over property of people who were not citizens or residents at the border or outside of the United States, did they have due process rights? So our argument was that the Haitians who were detained had rights under the due process clause, had equal protection rights, equal protection guarantees under the Fifth Amendment due process clause because it protects any person.
Right.
The interesting, I think, issue about what happened at the Supreme Court was how this was a case of huge and significant public attention for a couple of reasons. One is the obvious inequality of treatment between Haitians and others. But the other issue I think that was so dramatic was, if you think about legal history, there aren't very many cases where the federal government of the United States is being accused of racial or national origin discrimination, certainly not up to that point. This was in the 1980s. When you look at your legal history, right, most of the cases we learn about equal protection and due process are where the states have, or a city or a county have enacted blatantly discriminatory laws. Here, for the first time, we were pointing the finger at the federal government and saying, you, the federal government, are discriminating based on race or national origin. So that became the centerpiece of the case. And the question from a strategic point of view was, how do you argue this case? And I remember, I think some people panned our argument in a way, I think, because they didn't understand what we were trying to do. We recognized at the time that it would be extremely difficult to convince a majority of the Supreme Court that Ronald Reagan had discriminated on the basis of race or national origin when he made his pronounced statement about, we're going to interdict people and we're going to stop people at the borders and we're going to incarcerate them, that he intended to do so on a racially biased way, or the Attorney General, or even the Commissioner of Immigration. So our strategy was that they were issuing, and in fact they did issue, facially neutral proclamations. In other words, Reagan never said publicly, although we know what happened privately, Reagan never said publicly that they were just going to do it to Haitians, nor did William French Smith as the Attorney General at the time. So our argument was that while they were saying it should be applied facially neutral, in a facially neutral way, that it was the lower level immigration officers, the people at the border, when you come in, what we now call CBP, was then Immigration and Naturalization Service, the people at the border were making those decisions. When the boats were coming in, the people who were at the land borders and water borders were the people making the decisions as to who should be detained. The deportation officers, when they were confronted with the people. So the argument was, it wasn't high government officials, it was low-level government officials who were making this distinction. But and we thought that was the proper way to, based on, Munsung Wong and a number of other cases, we thought that was the proper way to argue the case.
Some thought that we should have attacked high-level officials for discrimination. But below, as you recall, the government argued there was nothing to stop them from discriminating if they wanted to, that they had total discretion to do so. But when they got to the Supreme Court, they switched and basically said, if a statute is neutral on its face, we still can't discriminate on the basis of race or nationality. That's statutory construction. In fact, that's what Justice Marshall picked up on in his dissent. And you could see Justice Marshall seemed to be upset that we didn't attack the high-level officials, which is what, he's the only one who dissented. And in fact, law clerk made it clear later on.
Or with Brennan, I think Brennan dissented with Marshall, right?
Yeah, I think he joined the dissent. Right, right.
Yeah.
But Marshall wrote that saying there was nothing to stop them from discriminating the base. They had total discretion. Therefore, the Constitution has to apply because there are persons within the meaning of it, and you can't discriminate on the basis of race and nationality. And that's what his whole opinion is based on. And it goes through chapter and verse about discrimination and parole and all that kind of stuff. But that's what Justice Marshall was upset about in the case. On the other hand, Ira is right. If we had tried to take on the upper level officials that way, I don't think we would have gotten very far. I think we would have lost the case. So, yeah, go ahead. No,
there's a couple of interesting things about the argument itself. First of all, Rex Lee, who was an experienced lawyer arguing in the Supreme Court and was then Solicitor General of the United States, decided to argue the case himself. Not very usual, not very typical that a Solicitor General himself would argue the case.
And Ira, that was the first case he argued as Solicitor General.
Oh, okay. So there you go. I mean, and so this was a high profile case. And he came in and, to our surprise, as Erwin pointed out, basically said, we don't discriminate. You know, as an official policy of the United States government, our regulations don't allow us to discriminate based on national origin or race, and we have no intention of doing that.
Right.
So, we're arguing, yeah, but they did it below, clearly. And even though they're saying that they're not going to do it now, our position is that they have done it and they could do it again. The court, it was very interesting because, as Erwin just pointed out, Justice Marshall says, hey, wait a minute. You know, the government is here. They're saying they're not going to discriminate. Well, tomorrow they could change their mind and say they are going to discriminate. You can't have a standard of government that relies on a Solicitor General coming into the court and simply saying things.
Right.
And that was the core, really, of Marshall's, very powerful, I thought, dissent, saying, you can't, what is he saying, really? Yeah, you can't believe these racists.
Right.
You can't believe these racists. They'll say whatever they're going to say here in the Supreme Court.
And he pointed out that the government switched positions from their argument below. And so how can you trust any of them? And which right. Went through and he distinguished cases claiming, the Mazzei and all those cases were different and they were all dicta. And what you have to do is get to the equal protection claim. And under the equal protection claim, we would have won the case, according to him. But we would not have gotten the votes of the rest of the court. But Rehnquist was pretty smart in doing what he did because he basically limited the attempts of lawyers in the future to bring these kinds of claims. Although he did say that if a statute's neutral on its face, you can't discriminate. Well, as Ira will tell you, many of the immigration statutes at the time were neutral on their face. And so in a funny way, this may have been a broader opening to attack discrimination than a constitutional case, but they could have also changed the statutes in ways that would allow them to discriminate. And they would have made the argument, we have total discretion in any event if we want to discriminate, which was the Marshall's problem.
And one of the other, I think, remarkable things was what Rehnquist actually did at the end of the decision. We always joke about this, and I've joked about this with my friends in the government, saying we won that case. And the government always says, no, we won the case because we were affirmed. What Rehnquist did, I think, was really intellectually dishonest. But what he did was to say the judgment to remand the case back to the district court is affirmed.
Right.
But not affirming anything in the opinion.
Exactly.
Because remember, the in-bank court said the government can discriminate. So what normally would happen if it wasn't a high-profile case, if the rest of the world was not looking at this, they would have said the opinion below is vacated and remanded back consistent with the instructions of the court today. But he didn't say that. He said the judgment was affirmed. So the government walks out of the Supreme Court and said, we won. We were affirmed by the Supreme Court. And, you know, I always thought that was truly remarkable. And it shows you in some respects how political even the Supreme Court can be in ultimately rendering its decision. Forget about what it says.
Right.
He wanted the government to be able to come out of this case and say the federal government doesn't discriminate. They were affirmed as to their view. That is, but they weren't. I mean, they truly, the whole opinion was vacated of the 11th Circuit in bank, and it was just the judgment to send the case back. You would never normally, do, you know, have a case that way. The other interesting thing, and it's just a side note, really on legal history, I think, we're in the process of, in our office, considering taking a new in-bank decision that was just issued by the 11th Circuit to the Supreme Court. And I was struck by how many calls and emails that I have received by what I would call professional Supreme Court arguers.
Right.
You know, today we live in a legal society where large law firms, in order to attract big clients, now have Supreme Court practices.
Right.
Where certain universities, like Stanford and Yale and Harvard and the more prestigious universities, have Supreme Court clinics.
Right.
And so as soon as they're constantly monitoring any case that might go to the Supreme Court, and as soon as they have these, computerized systems that show that this case has a split in the circuits or is otherwise important, they immediately jump on the lawyers who are doing the cases and offer their help. And I say that because we just received a decision this week, and within 48 hours, I received 6 or 7 requests of help. You know, it was nice that they would offer to help. Half of them obviously never knew that I had argued in the Supreme Court before and knew a little bit about immigration law. But it says something, because when I argued John v. Nelson, I was 35 years old, had never argued a case in the Supreme Court, and it was a different time and a different bar. There was no, quote, Supreme Court bar. I mean, there were people who were famous who had argued certain cases, but today it's become institutionalized because the large law firms sell themselves to big corporate clients by saying, oh, we've argued 30 cases in the Supreme Court, or we've argued 20 cases in the Supreme Court. So I thought it was very interesting, the contrast of, 30 years ago, whenever it was, 35 years ago, and today.
There were lawyers in those days, generally some professors, who contacted me and can I see your cert petition? And they came back with saying, well, why don't you put this case in there? And I said, why not? I didn't think so. And then an hour later, I got a phone call from the same person saying, could you put my name on the cert petition? Yeah. It was remarkable. So it wasn't quite as sophisticated, but it did exist. Let me make one other point. Not only did we litigate this case, but we found out that attorney's fees were possible under the Equal Access to Justice Act. We litigated that case up to the Supreme Court. We won the largest verdict under the Equal Access to Justice Act up to that point. And several of us threw in some money and created a scholarship for Haitian law students at the University of Miami, which is still going on today. So that was another part of the case that was unseen, I think, and is worth talking about a little.
Yeah, and I think all the attention that John V. Nelson got, all the pressure publicly that was on this, eventually on February 7th, 1986, led to the removal of baby Doc Duvalier. He left Haiti on February 7th, 1986, and began the transition, although it was a very tough transition and still is a difficult transition today, to the democratically elected first president of Haiti, Jean-Bertrand Aristide, then succeeded by Rene Preval, who became a democratically elected president. And for a short period of time, we had really true democracy in Haiti, where local organizations could come out, where there were community-based organizations supporting democracy. We set up the first human rights project in Haiti in the 1990s. And did the first human rights prosecutions. And I think all of this started really because of the clear vision of Haitians here in Miami who said, we want to be treated equally. We want people to know what's going on in Haiti. We want to try and get democracy in Haiti because that's important to us and to our families. And we're not here just to live off the United States. We're here because we truly are refugees fleeing persecution. And that, I think, became the centerpiece of ultimately, along with, of course, what was happening in Haiti and demonstrations and so many people being killed and, fighting for democracy in Haiti. But you had it going on both sides of the Windward Passage. And you had it going on both sides of the Caribbean, where the U.S. Haitians were demanding fair treatment and demanding an end to the repressive government in Haiti. And I think the legacy of Jean V. Nelson is that it really energized the Haitian community in Miami. It got people released. Haitians ultimately got residency through the 1986 amnesty law, to the Cuban-Haitian Adjustment Act, through the, we then later on pushed President Clinton to have deferred enforced departure, which ultimately led to the Cuban-Haitian the Haitian Immigration Fairness Act. So as a result of a lot of this litigation tied to political action, what you ultimately had is Haitians not only being released from detention, but ultimately becoming residents. And, I think Miami, and if I can just end on this, and everyone, I'll turn it over to you. I just think Miami is a great microcosm of what immigration's about, because if you look at how we treated Cubans, and the fact that we treated them so well, we gave them benefits, we allowed them to stay here, we told them they would become residents. They created an incredible city here. They created a city that's the gateway to Latin America, because I was here and Erwin was here in the 1970s when Miami was a dead city. And if it really wasn't for the Cuban community doing what they did and opening up Miami to Latin America, we would probably be just another backwater city as we are, we were in the 1970s. And you contrast that with how we treated Haitians so harshly. When we started this, the Haitian community had the lowest crime rate in Miami-Dade County. And because of the repressive measures, the way they treated Haitians, they wouldn't let them work. They wouldn't let them be citizens here. They wouldn't make them residents at the very beginning. That crime rate went from the lowest to the highest, and then became a self-fulfilling prophecy. So the bottom line is how you treat refugees and how you respect their rights and give them a sense of security and fairness and give them the right to be here and work determines what happens to your own community. And, I think that's a kind of a perfect summation of what we tried to do in Jean V. Nelson and what happened in the Cuban community.
So I think that's a very nice summary. So what these kinds of cases are, they're civil rights cases, but they're international cases. They hold governments' feet to the fire, the US government, which says one thing and preaches equality, liberty, freedom, and the rule of law, and then violates that in the treatment of people in their own country, as well as how we treat them here. And it always amazed me that people whose relatives came here a short while ago themselves would have that kind of opinion about anybody else, and why they wouldn't take them willingly to become a part of what America should be, a fabric of people all over the world. That's the greatness of America. Unfortunately, in this day and age that we now live in, we've seen the federal government do the opposite, divide the country with racist policies, with incompetence, with lying, with committing felonies on all levels. And instead of living up to our ideals, it's living up to our lowest base. And that's what was happening in our treatment of the Haitians. And that's why, at least to me, and I know to Ira and others, this was a cause célèbre. This was not just a regular case, an everyday case. And it's something that lawyers should think about as they practice, because if lawyers don't fight for justice with all the powers that they have, there won't be justice. And so the organization of this group of people pushing up from the bottom up, really, I feel that I've been honored to be allowed to do this kind of work. It's not that they be honored having me. And so, and Ira, who really is a hero in all of these cases and is the leader of the civil rights movement for Haitians as well as other people, knows full well how wonderful that honor is. So, you know, whatever other kinds of things people strive for, material goods or whatever, you can't put a price on how wonderful it was to do this kind of work. That's how I feel.
Thanks. Okay, I think we've used up all our time here.
Yes, it's been a wonderful discussion of background, the politics, and everything else that was involved with the case. I'd like to thank our two speakers, and I'd also like to thank everyone who's joined us for today's presentation. We will be having further Leaders in Law sessions. Keep an eye on your email for announcements. And I'd like to thank everyone and hope everyone has a great afternoon thinking about these thoughts. Have a great one.
Thanks, Aaron. Appreciate it.
Thank you. Take care.
Bye-bye. How do we get out of this now? Let's see.